Buying property, it's probably one of the biggest financial moves you are ever going to make in your entire life. And a lot of the time, we don't do it alone. We do it with a partner, a family member, maybe a friend. But what really happens when you share a title? It seems pretty simple on the surface, but there is a single choice, one little check mark on a form right at the beginning that can have absolutely life-altering consequences for everybody involved. So picture this. You're sitting in the lawyer's office, you've got the pen in your hand, and you see these two options: joint tenants or tenants in common. I mean, they just sound like confusing legal jargon, right? But choosing one over the other dictates everything: who gets the property if one of you passes away, how you can sell your share, and what your family is actually entitled to. This is not just paperwork. This is about protecting your future. So in this explainer, we are going to pull back the curtain on this critical choice. We're going to look at the two main paths you can take with co-ownership. We'll explore what happens when things go south and you need to break that bond. And finally, we'll see how the law steps in to untangle the financial mess that can be left behind. Okay, let's dive right in. At the absolute heart of co-owning property are these two completely different legal structures. You can think of them as two separate destinies for your property, and each one comes with its own rulebook and, believe me, some potentially dramatic outcomes. First up, we have joint tenancy. The easiest way to think about this one is like the all-for-one and one-for-all model. Every owner has an equal and total interest in the entire property. You don't own 50%, you and your co-owner, you both own 100%. Together at the same time. Now, for a joint tenancy to even exist, the law has these, kind of old school requirements called the four unities. But what's really interesting here is that it all just boils down to one simple idea: perfect equality. You've got to have the right to possess the whole place. You have to hold the exact same kind of interest. You get that interest from the same document, and you get it at the exact same time. Everything has to be perfectly balanced, right from day one. But the most important feature, and honestly the most dramatic one, is something called the right of survivorship. The legal jargon is just acroscentii, but don't worry about the Latin. All you need to know is that this one rule, it changes everything. Let's make this super real. Imagine three friends, we'll call them A, B, and C, buy a cabin together as joint tenants. They all have equal rights, they're all on the title, life is good. And then the unexpected happens. B suddenly passes away. So the big question is, what happens to B's 1/3 share of that cabin? This is exactly where the right of survivorship kicks in, and it's wild. B's share doesn't really go anywhere. It just kind of vanishes. It gets absorbed by the surviving owners. So A and C now automatically own the entire property, just the two of them. It is a true last person standing game. And this, right here, is where we see that hidden danger. The crucial point is that B might have had a will that clearly says, I leave all my property to my kids. But for this cabin, that will is completely irrelevant. The right of survivorship operates outside of the will, meaning A and C get the cabin, and B's family, B's heirs, they get nothing from that property. Absolutely nothing. Okay, that is a pretty stark outcome, right? But luckily, there's another way. So let's talk about path number 2. And see how this builds a totally different structure: tenancy in common. You can think of this as the more flexible, separate but together approach. With a tenancy in common, you own a distinct, defined share of the property. It's kind of like owning shares in a company. You might own 60% and your business partner owns 40%. It's your piece, you control it, and, this is the most important part, there is no right of survivorship here. So let's put these two paths side by side, just to make it crystal clear. You can see the single biggest difference is what happens when an owner dies. With joint tenancy, the property goes to the survivors, period. With tenancy in common, your share goes to your heirs through your will. And the shares themselves, they have to be equal in a joint tenancy, but you can split them any way you want in a tenancy in common. It all comes down to that automatic right of survivorship, the defining rule of one that is completely absent in the other. Okay. So what happens if you're in a joint tenancy, but the relationship sours or your life just changes? Suddenly, that all-for-one bond can start to feel like a trap. The good news is you can break it, and the legal term for doing that is severance. The law basically gives you 3 main escape hatches to sever that bond and turn it into a tenancy in common. First is unilateral action. One owner can just go and sell or mortgage their share, and that act alone breaks the joint tenancy for that specific share. The second way is the simplest, mutual agreement. Everybody just gets together and agrees to end it. And the third one is really interesting. It's called course of dealing. Even without a formal agreement, if everyone just starts acting like they have separate shares, the law can say, you know what, you've already severed the bond. This brings us to a fascinating legal question that honestly sounds like something out of a movie. Can you sever a joint tenancy with a zombie transfer? And this comes from a real-life case where a woman who was very ill and near death wanted to sever the joint tenancy on her home. Why? So she could leave her share to her estate instead of it automatically going to her husband. So her lawyers prepped the documents, but she passed away before they could be officially registered. Now here's the crazy part. They went ahead and registered the transfer after she had already died, a so-called zombie transfer, and the court said it was valid. Why? Because her clear intention to sever while she was alive was what mattered most. The paperwork was just the final step. It's an incredible example of just how powerful a single owner's intention can be. But, severance doesn't always solve every problem. What happens when co-owners just cannot agree on what to do with the property? This is when the courts have to step in and basically untangle the whole mess. So if you're at a complete and total stalemate, any co-owner can go to court and ask for a final resolution. The court has two really powerful tools. The first is called partition, which means physically dividing the property, but that's usually not practical. I mean, how do you split a house in two? So the much more common solution is for the court to just order a sale of the property and then divide up the money. Of course, selling the property is just the first step. Then comes the really messy part, the financial accounting. Courts have to figure out who paid for what. So core expenses like the mortgage and taxes, those are typically shared. But what about improvements? If one owner paid for a brand new kitchen, they don't just get their money back. They can claim the increase in value that kitchen added to the home. And if there was a tenant, any rent collected has to be shared. It's a really complex process just to make sure everyone gets a fair shake at the end of the day. And all of this, it brings us right back to where we started. As you can see, that choice between joint tenancy and tenancy in common, it's not just some tiny legal detail on a form. It sets the entire rulebook for your shared property. It decides what happens in life, what happens in death, and what happens when you disagree. That one little check mark on a document, it dictates absolutely everything that follows. So the next time you think about co-owning property, or heck, even if you already do, I want you to ask yourself this question. Your name is on the title, sure, but do you truly understand what it is that you own? Because knowing the answer to that is one of the most powerful things you can do to protect your biggest investment and your future.